Ms. Conklin, why is this eviction sought?
They're for non-payment of rent
All right. Is there a
and
written
unauthorized animals.
Ms.
Pardon?
Conklin, is there a written lease between the parties?
There is.
And under the lease, how much is the
Hello.
It's
Wait,
$360
Ms.
a
Conklin,
month.
one moment. Yes, I heard someone begin
Okay.
speaking. Who is that? All right. Ms. Conklin, thank you for that. Tell me, I'm sorry, how much is the monthly rent?
It's $360 a month.
350 or 60?
60.
360.
Yes, ma'am. Yes,
All right.
Your Honor.
Is any portion of that subsidized?
No.
What months of rent are unpaid?
January and February.
Was rent due for March?
It was
When is rent due?
on the 1st.
Right. Is your property under the Federal CARES Act?
No, Your Honor.
All right. What day did you provide the notice to vacate to the defendant?
January 7th.
Had the defendant previously been late on the rent before January?
No.
So January was the first time she was late with the rent?
Well, yes, but her lease began in December, so she'd only been here a month when she stopped paying.
Good afternoon, Ms. Tabolka.
Hi, how are you?
I'm fine. Ms. Conklin says that the defendant is behind on the rent. So my first question is it correct that the monthly rent is $360?
The plaintiff does not own the property to evict anyone.
The hearing begins with the judge asking Ms. Conklin why the eviction case has been filed. She explains that the eviction is being requested because the tenant has failed to pay rent, and there are also concerns about unauthorized animals on the property. The judge then asks whether there is a written lease agreement between the two parties, and Ms. Conklin confirms that a written lease does exist. When the judge asks about the monthly rent amount, Ms. Conklin initially hesitates, but eventually clarifies that the rent is $360 per month. The judge also asks whether any part of the rent is subsidized by government programs, and Ms. Conklin confirms that it is not subsidized in any way. The judge continues by asking which months of rent have not been paid. Ms. Conklin states that the tenant has not paid rent for January and February. The judge then asks when rent is normally due, and she replies that rent is due on the first day of each month. The judge also checks whether the property is covered under the Federal CARES Act, but Ms. Conklin says it is not. Finally, the judge asks when the notice to vacate was given to the tenant, and Ms. Conklin explains that the notice was provided on January 7th.
Plaintiff have a lease with the defendant that you're representing?
No, there is no lease.
Ms. Conklin, do you have a written lease?
Yes, Your Honor.
Could you provide a copy of that to the court?
I have not, but I have a copy of it I can provide.
All right, Ms. Tabolka, assuming there's no written lease, is it correct that your person you're representing is currently residing in property?
Yes, ma'am.
All right, and how did they come to have access to that property?
Julie let them in. I mean, and the property is not hers. The person that owns the property passed away. And it's in probate.
That may not be a defense, though. If Ms. Conklin is who leased it to the defendant, Ms. Conklin is her landlord. So if what you're saying is that the reason your person you're representing got access to it is through Ms. Conklin, then yeah, that would make Ms. Conklin the landlord. Ms. Conklin says that she has a written lease. You're saying she does not. Do you know
She
if
doesn't.
the person you're
There was
representing...
never a written lease.
That's fine, Ms. Tabolka. A written lease isn't required. Do you know if the person you're representing agreed to pay rent to Ms. Conklin?
She did not.
What was the agreement for why she got to live there?
Because she could live there. I mean, there was no real agreement. It was just, they talked about it and she said she could move her trailer in.
Well, then, Ms. Tabolka, here's the situation. If there's no lease and no agreement to pay rent, then Ms. Anderson is just a guest and she can be told to leave with 24 hours notice. If she has a lease, then she is a tenant and she might have some rights today. So I want you to decide whether or not you're representing this person correctly. Is there a lease and she's supposed to pay rent, or is she a guest because she just got to move her stuff in?
Well,
It's a difference.
Maybe they had a written, maybe they had an oral agreement.
If she had an oral agreement, then she is a tenant, and we'll get into the details of that lease.
Okay, let's do that.
Do you know personally what the information is?
It was really scattered. There's not really a formal thing done here. That's my concern.
Ms. Tobolka, are you a party to this oral agreement of any type?
No, ma'am. No, ma'am. I'm not.
How do you have personal knowledge then of an oral agreement if you were not a party to it?
I only have personal knowledge of what's going through the probate courts for the land, the property that's being rented out.
Okay. Probate is a completely separate thing from eviction. It may very well be that the land is being probated. That is not a defense to whether or not Ms. Conklin has the right to make the defendant, Ms. Anderson, leave. If Ms. Anderson is there because Ms. Conklin gave her permission, then that's either a tenancy or a guest.
Well, and then who determines that Ms. Conklin can give anybody permission to be a tenant there?
No one has to determine that. If Ms. Conklin had access, she can illegally let it out, and then Ms. Anderson would be a protected third-party purchaser for value, which we see a lot of, unfortunately.
And who allows access to that?
No one allows it. If Ms. Conklin was able to get access to it and gave it to Ms. Anderson, then Ms. Anderson's a tenant.
Okay. There's a lot of access issues here, but I guess that needs to be taken up in another court.
Okay. Ms. Conklin, did you find a copy of your written lease?
I do. Yes, I have a copy of the written lease. Yes, Your Honor.
Can you submit that to me right now via email?
Yes, I can.
I'd like to see the written lease because Mr. Bolka says that there's no lease whatsoever. And if you're here about money, you're going to need to establish that, she owes it to you.
Right. Okay. Yes, ma'am. Just take me just a second to do this. It's not, I printed it on my computer, but it's not, I have to scan it in with her signature.
Okay, that's fine. I'll also highlight for you, Ms. Conklin and Mr. Bolka both. When I reviewed the notice to vacate, it is an accurate notice to vacate because it does include a pay or vacate opportunity. So the notice that Ms. Tobolka provided did give Ms. Anderson an opportunity to cure the deficiency by bringing the rent current, in which case the eviction would have been voided. So I'll just say that I checked that. She did give the correct type of notice here. All right. Ms. Conklin, Mr. Tobolka, why don't we give y'all a few minutes?
Ms. Anderson was never served for this hearing. She was served for a hearing on the 12th. We just seen it when we looked it up. So that's why I'm attending for her on her behalf.
How did you find out about the hearing, Mr. Bolka?
By looking up the other case for Victoria Anderson. It's going to be the hearing on the 12th. And Julie has submitted three other cases for evictions there already. And she has another one against Victoria and another one against Robert Anderson coming up this month.
All right. We're going to take this on recall. Ms. Conklin, I'd like you to submit a copy of the lease to us. Ms. Tobolka, if you'll stay with us, you can turn your camera off. That way you're not going to lose all your power on your phone. We're going to do the other cases. We're going to come back and revisit this one, okay?
Thank you.
Yes, Your Honor.
All right.
The judge then begins questioning the representative for the defense, Mr. Beulah. He challenges the landlord's claim by stating that the plaintiff may not actually have the legal authority to evict anyone from the property. According to him, the person filing the eviction does not own the property. The judge asks whether there is a lease agreement between the landlord and the tenant, but Mr. Beulah claims that there is no written lease at all. The judge turns back to Ms. Conklin and asks if she can provide a written lease to the court, and she responds that she does have a copy available. The judge explains that even if there is no written lease, it does not necessarily mean the tenant has no obligations. The key question is whether the tenant agreed to pay rent in order to live there. Mr. Beulah argues that there was no clear agreement and that the tenant was simply allowed to move her trailer onto the property without any formal arrangement. The judge clarifies that if there was no agreement to pay rent, the tenant could be considered a guest who can be asked to leave with very short notice. However, if there was any agreement, written or verbal, to pay rent, then the person would legally be considered a tenant with certain rights.
Again, Mr. Bolka. And Ms. Conklin, you'll need to press *6 as well. And Stephanie, did we receive in the information?
I have not received a lease yet.
All right. Ms. Conklin, were you able to locate a written lease?
Yes, Your Honor. I did. I emailed it to JP3 Civil, and it would be coming from Julie Harris, not Julie Conklin.
Yes. It looks like it just came in.
Okay. Just give us a moment. It takes a second for the firewall to let us move things from one system to the next, but we'll take a look at it then. And Ms. Conklin, while you're looking, do you have it in front of you to refer to?
Yes. I'm sorry. Yes, I do.
All right. And when did the lease begin?
It began on December 14th, 2025, but I gave her some time because she was getting employed, so I gave her some time to get some money together. She had a new job, and I gave her till the 1st of January.
All right. So rent was due on January 1st?
Yes, ma'am. Yes,
How
Your
much
Honor.
is the rent under the lease?
$360 a month. But I'm sorry. It's $180 every 2 weeks. She gets paid every 2 weeks, so it's on the 1st and the 15th.
Okay. No, that's a different thing. If it's 180 on the 1st
It
and
is.
180 on the 15th, that's a different thing.
Sorry.
Oh, that's fine. Okay. Looks like the lease came through. Let me open it up here. All right. So it's just a simple part. It's a lease between parties. It is simply one page. Mr. Bolka, I'm sharing my.
As the discussion continues, the judge asks more detailed questions about the situation. Mr. Beulah admits that he was not personally involved in any agreement between the landlord and the tenant. The judge points out that this makes it difficult for him to provide reliable testimony about what actually happened. Mr. Beulah explains that his knowledge mainly comes from issues related to probate court because the property owner has passed away and the property is currently involved in a probate process. However, the judge makes it clear that probate proceedings are separate from eviction matters and do not automatically prevent an eviction case from moving forward. The judge explains that if Miss Conklin gave the tenant permission to stay on the property, then legally, she could still be considered the landlord in this situation. The judge also says that disputes about ownership or access to the property would likely need to be resolved in another court. At this point, the judge asks Miss Conklin to provide a copy of the written lease so the court can review it. The hearing briefly pauses so she can locate and send the document to the court.
Then the first time rent was going to be due was January 1st. Did she pay $180 on January 1st?
She did.
Okay. Did she pay $180 on the 15th of January?
She did.
Did she pay $180 on February 1st?
She did not.
Did she pay on February 15th the $180?
She did not.
Right. And has she paid for March 1st $180?
She has not.
Okay.
In the middle.
Now, Miss Conklin, my question is, she moved in December 14th of 2025, and you said that rent was not due until January 1st, correct?
Right.
And she paid
Yes,
rent
Honor.
January 1st and the 15th.
Okay. She paid increments of whatever she felt she could pay. I'm giving her a large credit. So she was never quite current with rent.
Conklin, here's the problem.
Yes, yeah.
You just now, I want you to be very clear. When did she pay rent January 1st of $180? Yes or no?
No.
What did she pay January 1st?
$20.
You don't even.
What did she pay on January 15th?
I gave her credit. She didn't pay anything January 15th. I just gave her credit for.
Gave her credit?
I just gave her credit.
Here's the thing, Ms. Conklin, what you're telling me today contradicts the notice to vacate that you provided. So your notice to vacate, which is only a 3-day notice to vacate, which I believe is improper because you're renting land and she has to have space. She has to have at least 30 days to be able to move her trailer. But even in this notice, you say that you're giving her notice because she didn't pay rent. But you just today said that you didn't charge her rent or that she paid it or that you gave her credit. So it's not quite clear to me that what I can do is this. I don't have to worry about it. The notice to vacate you gave her is insufficient on its face. Because you're renting land to her, you must give her a greater amount of time to move her trailer, and that is a different type of notice than is required for other types of residential leases. There is also...
Okay.
When the hearing resumes, Ms. Conklin confirms that she has emailed a copy of the lease agreement to the court. The judge reviews the document carefully and asks several questions about the terms of the lease. According to the lease, the agreement began on December 14th, 2025. Ms. Conklin explains that she gave the tenant extra time to get settled and find employment, so rent was not expected until January 1st. The lease states that the rent is $360 per month, but it is structured as 2 payments of $180 every 2 weeks. The judge reviews the document and notes that it is a very simple one-page lease agreement. It mainly allows the tenant to rent a space of land to park a trailer. The judge also observes that the lease does not include many additional conditions or detailed rules. After reviewing the lease, the judge asks Ms. Conklin whether the tenant made the first rent payments in January. Ms. Conklin initially says that the tenant paid both January payments, but further questioning begins to reveal inconsistencies in that statement.
And that Miss Anderson was not served by the constable. The address provided, no one was able to get to her at, and so as Ms. Tobolka pointed out, the defendant literally has no idea that there's a hearing today.
Okay, that's not true, but yes. Okay.
Not illegal, Ms. Conklin. I understand that Ms. Tobolka is here because she found out, but legally, she has not been served as required by law by the constable, and I can see that. They sent it back so we couldn't serve it. So, Ms. Conklin, today you're not meeting the burden of proof that you would need for an eviction, and specifically I'll highlight that a 3-day notice would be insufficient for a failure to pay rental for the land if you're renting land to her for her trailer. There is a specific provision in the property code about what you have to do when you're renting land to someone.
Okay.
All right. So, Ms. Conklin, today it's going to be a plaintiff take nothing, judgment for the defendant, I would say lack of service. You have the right to appeal that decision, though, Ms. Conklin, okay? If you wanted to appeal, the appeal bond would be $250, just the minimum we can allow, and based on what the rent amount is at $180 each 2 weeks, I think that's reasonable for everyone. Ms. Conklin, you also have the option of beginning the process again. You can do both. You can appeal my decision today. You can research, take a look at any of the information that we highlighted, specifically what to do if you're renting land for a manufactured home or a mobile home or an RV. What are the requirements around that? There are specific things you have to do if you're renting land as opposed to renting, like if you owned the RV and she was just staying in it, that's a different thing. But if you're renting her land for her to put her RV or her mobile home or her vehicle on, that is a little bit different. You might want to just educate yourself about that before you proceed. Okay?
Okay. Yes,
all right. Thank you both very, very much. Ms. Tobolka, you can let Ms. Anderson know that the case today was resolved in favor of the defendant for lack of service, but Ms. Conklin may very well begin the process again. Okay?
Yeah.
All right. Very best of luck to everyone. Thank y'all.
Thank you very much.
Thank you, Anna.
All parties are.
As the judge continues questioning Ms. Conklin, the situation becomes more complicated. She eventually admits that the tenant did not actually pay the full rent amounts in January. Instead, the tenant only paid a small amount, and Ms. Conklin claims she gave the tenant credit for other payments. The judge points out that these statements contradict the information in the notice to vacate that was filed with the court. The judge also explains that the notice itself appears to be legally insufficient. Because the tenant is renting land to place a trailer on the property, the law requires a longer notice period to give the tenant time to move the trailer. The 3-day notice used in this case does not meet that legal requirement. Another major problem is that the tenant was never properly served with notice of the court hearing by the constable. This means the tenant did not officially receive legal notification about the case. Due to these issues, the judge rules that the landlord has not met the burden of proof required for an eviction. The case is therefore dismissed in favor of the tenant. However, the judge informs Ms. Conklin that she still has the option to appeal the decision or to start the eviction process again correctly by following the proper legal procedures.